We don't.
Yeah, but like usually, it's you do like a discussion, but it's such a small, low word count that there's nothing. We can't really do anything.
Discuss state rulemaking, adjudication, rule.
But he doesn't want you to say like this could be this is a rulemaking because he just wants you to be like this is a rulemaking. C.
Right.
Yeah.
So no analysis, really.
Yeah. So the points are really about how many issues you spot.
Good times. Good times. One thing I'm thinking about next year maybe is teaching LAS here. What do you think? Sort of the pros and cons of the course are. Or you don't have to say it. Sorry. Just if you were like,
I just filled out my evaluation yesterday.
Oh, okay.
And I'm never too thorough on those. I usually give more like.
But you're gonna be thorough on this class, right? Because I need your feedback.
Well, I'll give it to you. I'll just give it to you. If you solicit, I'll just tell you. Like Professor Johns, I think is great because it's can be a very stressful class.
Right.
And he does a good job of kind of making it almost like a study camp and
very
gets people more engaged, and then does a good job of working on memorization of real principles. He's done a good job of identifying, from what I've heard from people that have taken the class and taken the bar, of identifying exactly what's going to be tested.
Okay.
So, and it's not something that everyone's taking classes on. So, I didn't take constitutional law too, so there's a lot of First Amendment stuff in there that I'm learning for the first time. So he's good at that. It's almost sometimes.
We're just kind of killing time until Allison gets it.
Sometimes it's almost too much like summer camp, kind of, because it's like your last semester, you're with all your friends, and it's easy to kind of goof off a little bit.
Okay.
And so you got to kind of worry about that.
Well, that won't happen in my class.
No, get the wedge out.
Yeah. Okay. No, that's cool. That's cool. Yeah.
But and then it does get a little repetitive with just doing the practice tests and everything else. But there's still so much room for improvement.
Yeah.
So work maybe a little bit more we get a written review back and it's always pretty positive encouragement. Good job. But
extra year.
And even kind of figuring out more strategies with that, focusing a little bit more on the strategies of how to read faster, memorize more, get stuff down quicker. I think would be helpful.
Okay.
So she goes missing.
So you guys, almost all of you, I think, know Julie, or at least who knows Julie already? Okay, so then why don't you guys introduce yourselves to Julie? This is Julie Nichols. Go ahead.
We're Bill and Will.
One of you, one and the other.
No, it's interchangeable.
I could go Bill today.
Bill is on the right.
Thank you.
Does that work? Yes, exactly. And why don't you just briefly explain where you're clerking and
Sure.
Yeah.
My name's Julie. I am clerking on the Colorado Court of Appeals for Judge Carparelli. I graduated last year. What? Do you want me to say something profound?
No, that's good. That's good. So Carparelli, he came the last time I taught this class. He came.
By the way.
Oh, cool. He was great.
He's awesome.
He was really, really great. So.
He's rather phenomenal.
Yeah. No, he's great. So this was kind of fun. Last time I taught this class, we had the simulation was based on a Fourth Amendment case pending before the Colorado Supreme Court. So same kind of thing where the case was developing as the semester went along. And Judge Carparelli had written the Court of Appeals decision that the Colorado Supreme Court was reviewing, and so it was really interesting to have him come in and talk about the case.
Which case was that? Do you remember?
No, this is 2010.
Oh, that's okay.
Yeah, I can't remember, but it was a Fourth Amendment case that there was a new Supreme Court rule about vehicle searches. So yeah,
Okay.
yeah. So you guys, so obviously super casual atmosphere in here, and just want to be able to explore some of the issues that have come up for you as a law clerk. And the first thing I would say, this is the thing I'm really trying to get a clerk to answer, as I've been reluctant to so far, but something you didn't know, something you wish you knew before you started, or something you didn't learn in law school that that you wish maybe you had.
Standard of review.
Okay.
I'll answer.
Yeah.
I mean,
good. Oh, that's good.
We were never, to my knowledge, I never was taught anything about, except for common law.
Right.
But that's a very, very different idea than what standard are you using to evaluate something on an appeal. I don't think that's anywhere
Yeah.
else,
Yeah.
maybe,
Yeah.
in law school.
Yeah, because these guys are very well versed. You guys want to throw out some standards of review?
Yeah, I'm taking a class with Judge Jones right now,
Yeah.
so
Oh,
that's
cool.
been a big discussion on, like, we're writing our briefs, you want de novo,
Yeah,
but a lot of things are reviewed for abuse of discretion. And then even though you have that standard, what requires actual reversal,
yeah,
like what amount of harm
Right.
you have to define.
what class is that?
Appellate advocacy.
Oh, there you go.
So it's good.
I didn't get to take that class.
Yeah, there's only 5 people that are in it too, so.
You've had some great small classes this semester.
Yeah, I lucked out. But yeah, it's something that I haven't gotten anywhere else. I
Right.
don't think anyone else really had a class that focused that much on standard reviews.
Yeah.
So,
And that it's not a clear-cut issue, right?
Oh, gosh, no. And, I mean, when you said, like, you want de novo review,
That's the appellant.
sometimes,
Yeah.
even as the appellant, sometimes, I mean, I think that
Huh.
I've had a couple of times where I can't come up with something, but if it dawns on me, I'll let you know. But particularly when the parties fight over, either when they fight over what is at issue, that's very challenging, and when they fight over what standard of review in certain contexts, that can be very challenging. Can also be really challenging when they agree, when everybody agrees on, so you have briefs, and each party's brief, and in addition, the lower court's ruling or order. Everybody seems to agree that this is the proper standard of review,
And
and
it's
that
wrong.
this is the proper analysis, and they're all wrong.
So you have to independently assess everything. pretty
Yeah.
much, Yeah.
Or, I mean, I think that's probably just a learning experience. I mean, everything I had to go on said, do it this way, and my judge was away, of course. So, just trying to gauging when and how and whatnot, what type of interactions you have with your judge and when. Really, it's all up to them, but it would have been really, really nice for him to have said, oh yeah, by the way, every single person here is wrong.
Tell me how, well, first of all, so when did the importance of standards of review become apparent to you?
Day one.
Okay.
I mean, they kind of.
It's required in the briefing, isn't it, to
Yes.
state the standard of review?
Yeah. If you don't have the new rules, basically say if you don't have an independent section of
Yeah.
discussing the standard of review, basically, I mean, for either the opening brief or the answer brief, they both need to discuss the standard of review.
And like the clerk can reject the brief or something, do you know? Or
There's
to that level? Or?
There's screening. The
Okay.
clerks, we don't.
Right, the clerk
I
of
mean,
the court.
we do actually. We screen them, but that's kind of an administrative part that we all do. But yes, if that's not in there, with the exception of pro se, there's a lot of exceptions for pro se, but the briefs will be kicked out and they'll either be able to resubmit or not.
Yeah, that's like rule 32 and 28 or something like
That's
that.
really impressive. Yes, that is
Yeah,
true.
Judge Jones do like the full briefs.
Wow.
He
Yeah.
didn't really hold back.
I really know that only because you said it out loud and I've read it that many times.
Yeah.
that- Yeah.
But so you've got the Colorado appellate rules on your desk and you're referring to those pretty regularly?
Not the latter.
Yeah.
I'm not,
Yeah.
actually. In fact, it's really quite rare
Okay.
that I'll be referring to them.
Okay.
There are certain when we do brief screening,
Mm-hmm.
they have checklists and whatnot laid out for you. So there's certain things that you need to be aware of, and that's based on the appellate. Those are based on the appellate rules. But aside from that,
It's kind of limited scope.
it's pretty limited.
Okay, okay.
Every now and then it will come up, but not very often once you're actually working with it.
So the Supreme Court grants certiorari, or whatever they call it in Colorado.
Yeah, certainly.
They do call it certiorari, okay. on a particular issue. So they will identify the issue, but the Colorado Court of Appeals doesn't have a cert granting
No.
process. And so I'm curious, in terms of defining the issue on appeal, you mentioned there might be some controversy about that. So the appellant, is it the burden's on the appellant to sort of attempt to define the issue, but is the
Correct.
appellee sometimes trying to shift it around, or are there preservation arguments too? I wonder if
Yes.
you run against that.
There definitely are preservation arguments. Yeah, no, the Court of Appeals is required to take any appeal, basically. There are a couple of civil exceptions, and I avoid civil appeals like the plague at this point, unless they're in my area, which is juvenile law. But yeah, we take everything. So we have, I mean, an unbelievable, they'll tell you, you know, I don't remember what the numbers are, but the numbers of opinions that the Court of Appeals puts out compared to what the Supreme Court does is just, it's hysterical.
Yeah.
It's quite common to hear comments about what the hell are they doing up there. I mean,
You know, I got a little bit of that from Judge Jones' talk the other day, but it is, I mean, it's the workload disparity and what it means for both the law clerk and the judge to write that volume of opinions under that type of pressure, right?
Yeah, he started his class with just like the amount of workload that the state appellate court sees.
yeah, it's crazy. And every judge has a, you know, kind of different relationship with deadlines. There is a schedule that technically we all are following, but for me, it's a rare case that I'm actually acting on those deadlines strictly. So for Kira, she will be on them 100% of the time.
Okay. So you have, so like in Vermont, there was no intermediate appellate court, so the Vermont Supreme Court had to accept all appeals as well, and they had two tracks, a rocket docket and a regular docket. Is there any kind of tracking?
There is some, it's minimal, and it's basically statutory.
Okay.
You know, because there are certain, the ones I know about are juvenile issues.
Right,
But there are
they have to be
certain,
signed more quickly.
exactly.
Right? Yeah.
It's also, you know, you kind of learn which types of cases the staff attorneys take before they come to chambers. So the Court of Appeals has a bunch of staff attorneys, and they are, they kind of specialize in different areas and are available to clerks and judges all the time, which I don't really think that many of us take advantage of.
So tell me more about that, especially when you don't have a co-clerk. I mean, how do you work with the staff attorneys? Yeah.
Well, okay, so I would include both staff attorneys and the library people. I mean, the library staff at the court is astounding. They are, it blows my mind. And I didn't start using them until fairly recently.
That's a great point, though. That's a great point.
And they'll tell you, use us.
But how do you work well with a librarian? Because I think that's something that maybe, you know, one does not necessarily have experience with. Like, what kind of situation would you approach a librarian? What might be a question you would bring to them?
For the librarians, they are the most amazing researchers on the face of the planet. Almost all of them are attorneys as well, not every single one, but they have, you know, library something degrees and JDs or some combination. So when I've used them, it's because I can't figure out the answer to a particular question. And I've kind of done everything I know how to do to figure that out. That's when I first used them, was I don't know how to answer this question. Also, in terms of, I wish I could remember.
So you'd be like, I'm researching you know, the automobile exception under the
Right.
Fourth Amendment or whatever, and I'm hitting a wall, like,
Basically, you can send them an email. I mean, the process is that you send them an email, and it's basically to the library staff, and unless you go down and talk to them, and then sometimes that person works with you. And you kind of explain as much of your case as you or they think you need to.
yeah.
And
Is there any
then,
confidentiality, but sort of like
no,
issue with the judges in terms of how much you talk about with librarians?
definitely not with the Court of Appeals.
Okay.
Everything
It's all
is
hands on
different.
deck, yeah.
Everything is different between the Court of Appeals and the Supreme Court, like everything. So, no, they're under the same
Right.
confidentiality umbrella and whatnot that everyone who works there is. So,
And then I am thinking of a curious situation here in particular, but what, you know, where some judges might not want their clerk to talk to another clerk about a case.
never happens on the Colorado Court of Appeals.
Okay,
Absolutely not.
okay.
And they make that as, it is the most collaborative,
Oh, okay.
collegial environment that I have ever worked in, period. And it is without question the, this is a group of judges, but, of attorneys who have done incredibly well. They are all brilliant. And they don't have egos. They do, of course, somewhere.
Right.
But it does not show. There's competition is not part of the situation at all. And every judge basically has an open door policy to a certain extent. There's no judge that I would feel like I could not go talk to if I wanted to for some reason. About my own stuff, about something I'm researching, about, anything. And they very much make that apparent to the clerks. So
they're sort of unified by the workload, it sounds like.
Yes.
Yeah.
And the fact that they're permanent clerks, or that there are clerks who have been there for a number of years, and kind of, it's not going to change. You can talk to anyone about anything. And you walk down the hall all the time to say, okay, what on earth is this? So that part's never an issue. It's the complete opposite with the Supreme Court.
Where it's very much in by chamber.
Yeah,
By chambers,
you're explicitly, I'll say forbidden, but I'm not sure if that's the word. They probably use that word. You may not talk law outside of your chambers. The clerks on the Supreme Court are, they do things together. They kind of socialize together. But there is no
crowdsourcing of an
nothing.
issue.
It's like, from an outside perspective, and this is an outside perspective, but it feels like they have to pretend that they're not attorneys, almost, when they're together.
Because they're so careful about what they will talk about and not talk about.
They don't discuss, it's not just that they don't discuss cases, they don't discuss law.
Yeah, that is really interesting. Okay.
There's some sort of kind of exceptions, but if you even kind of broach, in the interviews I've had for the justices, you even kind of broach the idea of, well, what if I have this, question that's on the nature of what is tort law, as big as you can get. And they kind of say, well, I suppose maybe, sure, but why would you? You would ask
It's a totally
people
different
in
culture.
chambers.
Yeah, okay.
Yeah.
Okay. And they're all multiple clerks in the
Yeah.
Supreme Court, so it's a little different too.
They all have, every justice with the exception of the chief has 3 staff people.
Okay.
And how they use them generally is a judicial assistant and/or permanent and 2-term.
So it sounds like for that reason, there might not be in that building a lot of interaction between the clerks on the second floor and the clerks on the third floor.
Correcting what you mean. The first, second, and third are both us.
Okay.
And the fourth is
so symbolic.
the big guys up there. But it absolutely feels that way.
Yeah.
I mean, we kind of like, can
I love hierarchy.
greet each other in the hallway.
So, I mean, like, going off that, like, I mean, this is, like, such a specific, but, like, Allison and I could have lunch. Allison's
You're definitely having lunch next
We
time.
can have lunch, but just not, we just don't talk anything. I mean, like,
Yes.
just talk about, like, puppies.
I don't think it's limited to puppies.
It's only limited to puppies. But, yeah.
Who are you clerking for?
Justice Hobbs.
Congratulations, that's
Thank you.
awesome. Yes, I mean, it's not like you can't fraternize with the enemy. It's like there's none of that. But, and quite frankly, I kind of feel like it's quite possibly stricter between Supreme Court clerks than it is between a Supreme Court clerk and an Appellate Court clerk. But I don't have any idea why that came out of my mouth. I don't know why that would be.
Well, I think there's something interesting going on. It's a little hard to put your finger on, but I'm curious if, what your thoughts are, if you guys have thoughts about what is that culture about. We've talked a lot about decorum and sort of, because there's confidentiality and then there's decorum.
Yes.
And, for some judges, I don't know what explains the difference between the Court of Appeals and the Supreme Court, but for some judges it's sort of, really a black box around their process, their conversations with the clerks, all of that.
I'd say it's for every justice.
Yeah.
The exceptions are that Marquez and Boatwright don't work that way naturally. So
She's so candid and open, Marquez.
she's incredible.
Yeah.
They don't work that way.
Yeah.
But the rest of the court does.
Yeah.
And the kind of assumption is that Justice Rice will be the next Chief Justice.
Mm-hmm.
And there's no way that anything of that nature will change
Mm-hmm.
under her.
Mm-hmm.
So
part of it's just conservation of that culture over time, right? If that's the culture
Yeah.
50 years ago, it's the culture now. But what do you guys have any other
I
thoughts?
mean, it's like it's a Supreme Court issue. You have 9 judges, right? Well, there's a seven on the panel. And it did sound like there's a lot of that political debate before decisions made.
Mm-hmm.
of
And it's always the
of
same
where this-
7 people
Yeah.
that you're interacting with, right?
And so I think, like, allowing any kind of that discussion outside of chambers, it's like intel leaks to the other judges.
But isn't it interesting that it's kind of a competitive and political sort of dynamic as opposed to a more cooperative one? I mean, again, this could be workload, and because the 3-judge panels are mixing up, right? So the work dynamic, and it'll be the same thing for you in the 7th Circuit.
Yeah. But I mean, I think that,
It's a different work dynamic.
and plus I think the Supreme Court though takes like 10% of cases, so, I mean, they just have,
Taking their sweet time.
yeah, and they can pick them, look at them, and.
Why would
appellate
that?
court-
Why would that shape the culture? That culture.
Well, the
of
culture's more
decorum.
like a workhorse culture for appellate. I mean, they need to get these opinions out, they need to get decisions, they need to get this, like, decision correctly made. Whereas like the Supreme Court, you're kind of trying to decide policy, the direction of it, and leaking that early.
Well, they're going to, so
Well,
by
others.
the nature of the cert process, it's going to be more controversial, potentially controversial maybe, issues. I mean, those issues have to go to the Court of Appeals too.
Right.
But the sort of symbolic weight
Yes.
increases.
I would add that the U.S. Supreme Court is nothing like the Colorado Supreme Court in this particular manner. So, just as,
Elaborate on that.
I mean, they talk to each other all the time. They're consistently trying to convince each other of all, it is an active, I mean, different justices do so differently to my, extensive knowledge, but, they
Which is what
will
people say collegial
regularly
court. I mean,
go.
yeah.
Yeah. I mean, you'll regularly have justices going from chamber to chamber saying, okay, you're wrong, let me tell you why, join us. I mean, that's a big part of, the way that the U.S. Supreme Court works. And it is
So is it
non-existent.
more battling through drafts of majority opinions? I mean, that, like the Vermont Supreme Court too, there was some breakdown in collegiality, I would say, in certain eras. And that it was really, I'm not gonna go to your office, your chambers, you know, my brethren justice or whatever. I'm gonna write this opinion.
Yeah.
And then see what, you know, where the chips fall, and then you're gonna write an angry dissent, and I'll respond to that. I mean, is it more done through?
That's actually something that Justice Hobbs did comment on. I went to the drop-off by bar application last Friday, and he was hanging out in the lobby chatting with the security guards. Just ran into him, and he was asking how his class is going, and we were talking about it. And I said, oh, you know, we had Judge Jones come in, and he told us about, like, you know, their work style, or his particular work style in the Colorado Court of Appeals. And I said, and he said, well, what was most interesting to you? And I said, the fact that they draft an opinion before oral arguments. And Justice Hobbs was like, oh, I can't believe they do that. And then I was like, what? He's like, yeah. And then
Because that's not fully airing the case somehow.
well, I
Or is
said,
that-
as a attorney who, you know, if all goes well, maybe I would be in front of the Colorado Supreme Court someday.
Yeah.
You know, it's uncomfortable to think that they've already drafted an opinion and that what I'm saying is not convincing them 100%.
So Judge Jones really made this point about oral argument kind of being a wash. And I think that even to me, hearing that was a little, you know, was sort of surprising.
But I see from the workflow why
Oh, yeah.
why they wouldn't wait until after oral arguments.
Well,
that's
I
actually-
would add to that I mean, as a matter of right, every appellant can request, the default is to have oral arguments, technically.
Right.
Like, technically, the default is that you have them, and therefore, if you don't want them, you waive them. But that's really in language only. The percentage of cases that we have that have oral arguments is significantly smaller than that we do have oral arguments. And it's actually quite a, I haven't learned, I don't know all of this so well, but there are real strategy and, you know, technique decisions in terms of whether you want oral arguments. And it's, yes, every judge has read all of the briefs, and yes,
But there's only a judge.
there has been a draft PDM written when orals happen. But you don't have anything beyond that. Like, you're not going to have, there's all these stupid colors, but that is one of the hardest things to learn, I swear.
The colors of the
About-
brief covers, or no?
It doesn't matter. It's
Published
about
or not.
published or
Oh.
not, and pink is in between some of them and not
Okay.
others, and then suddenly you need a pink.
I love it.
Anyway, it was one of the most stressful parts of orientation, just because it was something I could hold on to and go, I have no idea what you're talking about. You're talking about colors. Why are colors relevant? I'm sorry. Anyway.
Do you get to watch a lot of oral arguments, or?
Yeah, that also depends on your judge.
Okay.
You can watch when, you know, some judges expect their clerks to watch anytime X. So anytime their division has orals, anytime their case, you know, I don't know of any clerks who don't choose to come to orals on their own cases that they themselves have worked on. And then you can go whenever you want to.
And what's your impression of like the level of advocacy, and also, you know, if we're starting with this assumption that oral argument is kind of a wash, maybe at best you can, not at best, at worst you can lose your argument at oral argument.
I wouldn't call it a wash.
Yeah.
I would
Well,
I would definitely disagree with that.
Yeah, so the PDM is there because a lot of times that's going to be the right course, but something could happen at oral argument that changes the course.
Oh yes, absolutely. I mean, things happen at division conference. So the PDM, after a PDM is written, which is kind of the clerk's first job, more or less, there's going to be, at absolute minimum, one division conference on that case. Those changes will be incorporated. It goes to an editor. I guess that is the minimum.
And the editor is the site checker, you guys don't? in a sense, site check?
No. That's another big difference, which I find, again, I'm totally biased in the Court of Appeals, but we have an editor.
Right, Judge Jones talked about
And
this.
she, because of her, I do all my citations and I check them, I get them wrong occasionally, but, so she'll fix that. But I've read, I don't know how many Colorado Supreme Court cases I've written that have completely wrong punctuation or misspelled words or no paragraphs.
They need one of these editors.
And they
So she's doing
they think
blue
it's-
booking, or she's doing blue booking and substantive?
Like proofread.
She proofs everything. She doesn't do any of those things, as in,
Well,
it's always done
Right.
first. But she reads it for content, substance, blue booking, grammar, everything. So we'll get a comment back where she'll say, you haven't ever mentioned this person before. Who on earth is he?
Oh, God, I love editors.
Does she do
real
that?
editors.
What
That's
stage
awesome.
does she do that? Like, does she do that before you give it to your judge? Or
No.
So, like, before it goes out?
Yes,
Okay.
So you're gonna get a fair amount of comments back from her.
it depends.
Yeah, sometimes at least.
I always get some, that's for sure. My judge will have always written, he will have always worked on the opinion before it goes to Wendy, is her name.
But she's retiring. That's what Judge did. Because
She was
Judge
retiring.
Jones was like, she's amazing, and I was like, yay. And
Like,
he's like,
no,
but
we
she's
need
leaving.
Wendy.
I was like, no, don't leave.
That'd be a great career opportunity for someone who's very detail oriented.
And who is on, she's probably the only person who sees, I would say, 99.5% of every case that comes into the court. And her turnaround time is faster than almost anybody else in the building. So that's amazing. I guess I kind of knew about that, but they're gonna replace her somehow. They don't know how.
There are not a lot of people like that,
No.
those skills anymore necessarily. So I want to talk a little bit about, so in terms of clerk's responsibilities, and we've talked about obviously drafting opinions as being one of the primary responsibilities of law clerks, and then bench memos in the cases where the judge is participating in oral argument, and this I think might even happen at the district court level, a bench memo for a particular argument, which is different. The PDM kind of
Totally different.
started, conceptually maybe seems like a bench memo, but it's not. It's sort of like, okay, we're ready to go with this if things turn out this way. Whereas a bench memo is, judge, you might want to look into this issue or ask about this issue. Here's the background of the case. It doesn't purport to try to decide the case. But then, so those types of drafting responsibilities. But then the site checking work, in some courts, I don't know if you guys know, for those of you who are not at the Court of Appeals here, what the situation will be, but in Vermont, you had a co-clerk, which would be a clerk for a different judge, actually, in that case, or different justice. And that person would both blue book and look up your citations to make sure they were correct. So.
That's a chambers by chambers thing.
Yeah, okay.
And I would say that's true of both the Court of Appeals and the Supreme Clerk, the Supreme Court, however they, check that work is up to.
Interesting.
So many things vary by chambers.
Yeah.
That's, I could have my co-clerk look at my sites.
But that's not your practice.
No. I check everything and I still get things wrong.
Yeah.
But that's part of why we have Wendy.
Yeah.
And I don't remember if you asked a question.
Well, actually, I'm going to see if you guys know what happens at your courts.
No.
Okay. No, okay. You especially might have a co-clerk system, but.
Yeah, that's what I expect, is just to have other co-clerks to edit it, but I don't know for a while.
That's not the Seventh Circuit.
Yeah, I think we are responsible for all of our own.
Interesting, because I think it's critical to get another set of eyes. I could never, I'm
Well,
terrible.
Yeah, I know we can bounce off the other two, my
Yeah.
two co-clerks, but
But it's not like a
not
systematic thing.
outside of. Yeah.
Right,
Oh, no.
right.
Don't bring your piece of paper outside of the.
But what I was going
room.
to say, the other part of my conversation with Justice Hobbs was, so I mentioned the oral argument thing, we had a little chat about that. I mentioned and then I said the Court of Appeals sounds so interesting because it seems like the judges really collaborate on the opinions. It was also about that. And how can I go back and forth like that? It's so casually, blah, blah, blah. And he said that everything that leaves our chambers is written. So
I don't
think they like pop in and chat.
Yeah, no, it's
which is
really
actually,
interesting.
I don't necessarily see that as a positive, but the not chatting is positive.
But even he certainly was aware of the cultural difference and that he has a
Yeah.
commitment to the culture of the
Okay.
Supreme Court.
Yeah, and it just sounded like, I don't want to mischaracterize his feelings on the issue, but it sounded like because of the amount of work and back and forth that goes on with the clerks and within the chamber to put together the opinion, it sounds like he would not prefer someone nitpicking his work as that was happening. If I could.
Right, so it's kind of like that's part of decorum, right? Putting your best face forward. People don't see you without your robe on, or whatever it happens to be, sort of metaphorically, whatever it happens to be. And I don't know. I mean,
I think we just struggle in our little vacuum, and that's
yeah.
It's also
It's a different
they
intellectual
have a
process.
there are different ideas about what it means to be independent, and that's part of what it comes
that's
down
good.
to.
No, that's good.
There are justices who will say that even having somebody check your punctuation means that it's not an independent it's not an independent exercise of judgment. So if making sure that you have a period or a comma, it kind of destroys the concept of an independent judgment, then anything above that obviously does as well.
Yeah.
So, and they don't change. I mean, it is a very rare occurrence. Some justices and sometimes they will acknowledge that there is a dissent,
Right.
and say one or two things about that, but often there's no acknowledgement whatsoever of the dissent.
Yeah, Justice Marquez mentioned that there's not kind of the practice of big back and forth.
Some with the dissent, but the idea is that an opinion comes out of a justice's chambers, and it is it. The only way it will ever be touched again, ever, is if they lose the majority.
Fascinating.
It's the only time.
Yeah, because like I said, in Vermont, it wasn't super collegial, but there was a lot of the dissent is wrong because of this, and back and forth or whatever. So, well, that's fascinating. Very interesting.
Yeah.
Okay. You guys thinking about any questions? I'd like to encourage. I know I tend to blab, but I'd like to encourage.
So do I.
you
Sorry.
To think about questions.
Are there any standards of review you use regularly besides de novo or abuse of discretion?
Shouldn't that be a simple question? I mean, the answer is yes, but I assume your follow-up is what?
Gotta look it up. I mean, it's not cut and dry. A lot of times you go. I mean, special area. I don't know if juvenile law has special.
The special
standards,
areas I'm
but-
kind of even leaving out.
Yeah.
I'm not even
Right.
touching that. So this is just like the basic civil or criminal appeals that you'll get. Is that a list?
Yeah.
What's it say?
You have like de novo, which is question of law, is the best review.
Depending.
Usually.
Yeah, what you're looking for.
Yeah.
And it's not, okay, sorry.
And then abuse of discretion is I guess there's a mixed standard. Yeah, between kind of like law or kind of a fact question. And so abuse of discretion is usually like a factual question. And the
So-
mixed standard is kind of a little fact and law.
If you're reviewing de novo, do you have to defer to every fact that the court below held?
I don't think I think you're restricted to the record on de novo.
Okay, what does that mean? in terms of my question.
Testimony,
See, I want to be a teacher.
like testimony, briefs, motions.
But the fact finding is not supported by, if no reasonable fact finder could have found the fact
Yeah.
based on what's in the record.
But I don't
then
think
you're
you
not
can
obligated to.
But I like, you
adhere
can't
to it.
submit like new evidence, I
Ooh.
don't think. after
No,
the trial court
absolutely
period.
no.
You can ask for
new
judicial
evidence.
notice if you're a
Yeah.
clever appellate
You
attorney
can.
from Holland and Hart.
That's a little.
Are there any attorneys that have done horrible things? I'm just curious.
I mean, there are times I don't know
So
the
many-
attorneys
so
well
many
enough.
horrible things, yeah.
You know, I mean, like there are clerks who see that this person has written this brief and they just are like,
It's not credible.
fuck, excuse me, but like, absolutely. I've had, the most amazing one that I had was, well, I don't know. No, I'm not gonna say that. One of the most amazing ones that I've had is where there was a, it kind of, there was a sentence that led into something, says that this source says stuff about this issue. Quote, block quote, well, not quotation marks, but still, implied quotation marks, written out, cited. The cite and the, thing they said in the sentence were the same source. Nothing else was consistent. I mean, those words were nowhere in,
Unbelievable.
nowhere in the cite, in the source they cited. It just, that was not, those words were not there. They were in fact from a case about, 75 to 80 years earlier, talking about something else.
Okay, so how does that happen? How does that happen? Because you guys are going to be practicing attorneys
Did they go to
also.
law school?
How did that? They sure
Because not everything that a judge says is fact.
Or
That-
law?
Or law, or anything, is not true. My judge will say that the one thing that he wishes that no matter who he hires, it always takes a long time for clerks straight out of law school to believe that because there is precedent, that means it's true. Sometimes it means it has to be followed. Sometimes it means it might have to be followed. Sometimes it means it's so freaking not correct that it's not appropriate to not comment on it. But I struggle with that all the time. I will say, but judge, this says that, and he's like, yeah, fine. I don't say it.
And is that just between different panels, or are there any politics around a panel being like, well, we know that our brethren decided this, 2 months ago, but we're going to go in a different direction? I mean, is that something that's discussed openly, or?
There's no. I mean, there's technically nothing that another division of the
Right.
court says is binding
Right.
on any other division. It's not binding on those judges who were on that decision. It's not binding on anybody except for the people below. So you distinguish, and you say to the extent that this is to the extent that this analysis does not conform with our divisions, the other divisions' opinion and blah, we disagree. But yeah.
We were talking about standards of review, and I wanted to make sure we got everything kind of. I'm not saying that that's correct, but but to understand there's kind of a spectrum in terms of the standards of review, and that there's reasons. The underlying reason for the spectrum in standards of review is that appellate courts are specialists in law and trial courts are specialists in fact. And so unless the trial court, appellate courts can't retry the facts. So it's not only that they assume that the district court or the trial court was correct in its factual findings, but also that it's not within their capacity to really revisit those, even if there might be, some error.
Under certain standards.
Yeah, yeah. So it's an inquiry that should be undertaken anew every time. Look at what the parties claim that the standard is, and then do your own investigation on that issue.
And then just what does that mean? I mean,
Right.
really, it means something.
Right.
It means something different in different contexts,
Right.
which is very confusing.
Yeah.
Anytime you have to address harmlessness, in fact, one of the things that the Court of Appeals is trying to do, Judge Terry, is she really wants the court to have something resembling a consistent idea of the concept of harmless error and harm and things of that nature. So she kind of
That's great.
is focused on that a little bit.
Yeah. And you have harmless error in both civil and criminal cases? in
I think so.
Colorado? Okay.
Yeah, you can.
Okay.
Absolutely.
Okay. Because some judges will have like a policy of, there's no such thing as harmless error in a criminal case, but.
Yeah, nope, we sure don't have that policy.
Yeah, right.
What do you wish law schools did to teach? Because I interned for Justice Rice, and the clerk was like, "Oh, that's harmless error, right?" And I was like, "I know what harmless means, and I know what error means. I've never heard that phrase, but sure, it's harmless." So what can this class next year do, or like, what do you think, or what can we do before we start our clerkships, or just be aware? We've talked about it in this class, and we know to not trust the parties even if they agree to do our own research. But what can
and there's a point, I just want to say there's a point to this too, because one of the things we're doing is creating a model syllabus for a judicial clerkship seminar class, so really want to think through those issues, yeah.
And just for like other professors to incorporate in 1L, because
Are you going to advise them to do that?
maybe, yeah. Because that was not a good
Our briefs
feeling.
in legal profession, or not legal profession, legal, whatever it was.
And LP.
LP, yeah. we never even really
I
talked
sat
about
with my
standard
partner
review
for
and
like
that.
6 hours trying to figure out what to put in the standard review section of our brief, and we just put all of them. And then
Professor, how'd you do it?
Professor Ryan was like,
Just
she's
do it.
like,
Our professor
I'm not
gave
even
it
going
to
to try to
us.
get into this with you. I'm just going to circle the one that's correct.
Yeah, our professor was like, just
Yeah,
copy and paste this part, and we were like, okay.
Yeah.
And we
Judge
copied and
Carparelli
pasted.
came and talked to us for an hour about standards of review.
That's good.
He's pretty passionate
Well,
about it.
Yeah.
He's passionate.
Lawyer in process.
Oh,
Period.
Yeah. When you hit upon his particular things, which are generally the things that he talks about, he is passionate.
love it.
He's currently, I'm currently reaping the results of the contagiousness of his current addiction, obsession, something of Persian rugs.
Who doesn't feel passionate about Persian rugs?
Absolutely.
So that sounds like standards. Well, and I think when we say, standards of review, that would be an important thing for and not only prospective law clerks, but also any prospective litigator to know about. I think that's a really good example. And it also, I think it ties into some larger issues, not just about learning about appellate process, but maybe, and don't repeat this, but like learning about civil procedure in a more functional, kind of realistic context.
Definitely.
Yeah.
Definitely, yeah.
Like I really like the idea of
Marcia's
upper level civil procedure classes.
Oh,
you know?
yeah,
Because
yeah.
maybe there's one thing you need to get done in 1L Civ Pro, but there's a different thing you need to get done. Civil procedure is so incredibly important to practitioners, and it kind of is relegated to 1L year where it's really hard to process what it all means.
All you're doing is memorizing.
Yeah.
There's no way to do it otherwise.
Yeah. Yeah. Which is
Sometimes
interesting
you have to
too.
memorize phrases.
Yeah.
Sometimes you have like little welcome mats and things, but
But yeah, attorneys don't memorize rules. Attorneys, it'd be malpractice to rely on memory of what the standard of review should be in a particular case. Even you got to look it up, right? So that maybe is a
But
bigger
there-
theme in terms of curricular needs that would better prepare grads.
but
They
if
just scaled
you're
down their Civ Pro from a year to a semester too. But I did my internship at Denver District after that, and I was running across civil procedure left and right that I'd never seen before, and it was a little scary. I mean, my judge was like, "What? It's one semester? Like, take the advance. Like, you need it."
Did you do?
No. But
I don't know
Well,
what advanced, yeah.
I would say that, I mean, back to, whatever the very first question you asked was, something
I
about,
wish you had known.
I wish I,
Going to
yeah,
internship.
right. I was thinking of two things. One is standard of review, but the other one is that there is no feasible way to even get students to recognize in 3 years the extent of what everything relates to and what you don't know.
Yeah, you don't,
Like,
I mean, I say
you're
this,
coming-
they get offended, but you just get offended, but you don't know anything when you graduate. I mean, I didn't know anything when I graduated. I knew a lot less than you guys know going into my clerkship. But you're at the beginning of the process of learning.
It's fascinating and frustrating and ties back to one of the things that I'm really interested in and kind of have focused on in a different way. But it causes a lot of problems. So, for example, we all took crim law, right? And so how do I even ask the question? What are the things that make up a crime?
Elements.
Right. Okay. Right, okay, but yeah. So, exactly, and we're taught that those are elements. Yeah? And then, what are all the other facts that are in the statutes when you say, okay, what does it mean to commit the crime of aggravated auto vehicle theft? Because there's a lot of other things that it says there.
Factors.
More conditions.
Or condition, right, okay. And sometimes those other things change your sentencing range. So if it's a fact and it can change your sentencing range, what do we call it?
Do you guys talk about sentencing in crim law?
No. In crim law, no.
Okay.
But we talk, I mean, like, I swear somebody told me, Goel, I'm positive she told me that there were things called elements and that there were things called sentencing factors or sentence enhancers or something like that, right? And I thought that meant something, like, particularly with an element. I thought that a crime has elements and that should not be complicated. Okay, sorry. We are just going to be publishing now, in 2 weeks, the very first case I worked on as a clerk. I interned with the judge before, but as a clerk, the first case I got as a clerk, we are now publishing because of the extent of this particular confusion.
About whether a particular element was satisfied?
No,
Or
what it is.
what the crime is?
If something is an element, you know a couple of other things about it. You know that it has to be proved beyond reasonable doubt and that the jury has to decide it and that it has to be in the indictment or the whatever you are calling the thing, charging document. So if you know that the thing is an element, you know a bunch of other things. If you know that it is not an element, you don't know anything else than that it is not an element.
So yeah, you
Meaning-
can't give a specific example, obviously, because you've got this case on the brain, but,
Well,
but it's
think
a
about-
problem of legislative drafting?
It's partially a problem of legislative drafting, but it's also a problem of case law. So think about priors. So any prior conviction almost always is treated as a sentence enhancer. Sometimes it's an element. Because there's a crime that you can only commit if you are a felon. Right? So
Which
that
is really kind of, talking about the
means-
equal protection stuff, really pretty crappy.
Yeah. So that's one thing that everyone thinks is clear, that that is a sentencing factor and not an element, except for when it isn't.
When it is, right?
Or whatever. And so something that a lot of the cases I've dealt with, particularly on direct appeal, oh, that's something else. I don't think it ever dawned on me what happened after direct appeals for criminal
cases.
Like any of the post-conviction stuff that you can do. Like, have you guys learned about that?
There's a habeas class or something. I think there might be a habeas class, but it's not part of the core criminal law curriculum.
And is it exclusive to habeas, or does it also include
It's probably federal habeas and not,
Rule 35?
Yeah.
Is that the
That's
class you took? That came in?
Yeah, the constitutional capstone.
Yeah.
But they
Was
teach
it a
you about
capstone?
like the state.
Yeah, great.
But
But it had that feeling of a capstone experience. I'm just curious. I love that word. I think it's so
Where was it?
I heard it was a lot of work.
Yeah, it was a lot of work, and I'm not in that program.
Yeah.
So
Oh, okay.
I just wanted to do it for fun.
Great
So yeah, it wasn't really. Wasn't as fun.
But did you
as I
guys
thought.
learn about the intersection of state and federal post-conviction relief and stuff like that? Okay, okay.
Well, if you're going to do state, you're going to be in a state court. Take a look at Rule 35. There's something concrete I can say. I don't know what the equivalent is for federal. There must be something other than federal habeas post-conviction, right?
Well, there's statutes that sort of provide a process for habeas, but it's not like Rule 35.
Is there any way to complain about your counsel in?
It's all the same thing in federal.
It's all under.
It's, I mean, because
Habeas
you don't
stuff?
get, like, in state you get 2 rounds, right? So you can do the direct appeal and then you can
And
do.
you can't raise
habeas
ineffective
corpus, you can't do
assistance on direct appeal on the federal level, I think, right?
You're not supposed to
Yeah.
on direct.
Yeah, so.
Everyone does.
But so basically, and I'm not a habeas lawyer or a criminal lawyer at all, but my understanding is you have your trial, your direct appeal in the criminal case, then you have your state post-conviction relief, and then you can have your federal post-conviction relief after that.
Yeah, but you can't appeal what happened in your direct appeal in your federal habeas unless you took it through direct appeal.
Okay.
But so there's, yeah.
Well, okay, so in that
And those
situation
kinds of
also, I would
issues there.
say that post-conviction stuff, and if you do not have Rule 35 issues within the first 4 months you're there, it will be very shocking.
I've
done like 5 in a row.
In the 10th Circuit, they had attorneys who specialized in habeas issues, but they had staff attorneys rather, but so they don't, that goes to clerks and not
Yeah.
to staff attorneys. Okay.
Yeah.
That's
But
complicated.
that's another thing. I mean, there are specific staff attorneys who are experts in criminal law.
Yeah.
So the first few times I was going, I don't even know what this is.
Yeah.
So befriending a staff attorney is really useful.
So if you're going to be a clerk, it's different, I think, between federal and state clerkship, but there are procedural issues you want to be cognizant of, and you're saying also some substantive issues that, if you're a clerk, well, in both settings,
Yeah.
you can kind of predict certain types of issues that are going to come up and to sort of be aware of that
Yeah.
more. Okay.
And you do learn it, and you learn it quickly, but
But to even know it's coming, I think, right? You might not learn it in and out in law school, but to kind of know what sort of issues might be coming on the docket.
just some idea, I guess. I don't know.
So how many Colorado Court of Appeal or state court or Supreme Court cases have you guys read in law school?
Probably a dozen.
Yeah, and what context was that, do you remember?
Like property law, we read some Colorado cases,
Okay.
printed out.
You had Marsh
different
for
classes, they would
anything.
throw them in.
Yeah. Did we read?
Oil and gas, read a lot of.
Yeah.
Yeah, criminal procedure, we read quite a few.
Okay.
Mhm.
And then for Jones's class, I was forced to read quite a few as well.
Yeah. But right, it's sort of not this undertaking of a study of Colorado's jurisprudence sort of as a discrete object or whatever like that.
And probably some of the biggest Colorado Supreme Court cases,
Mhm.
I'm sure I had some exposure to, but
Mhm.
not much.
Okay.
So yes,
Yeah.
where you're going, I mean, I now can open a Colorado Supreme Court opinion. I cannot do this with the Court of Appeals, but I can open a Supreme Court opinion and read the first few paragraphs, skipping who authored it, but you know, and I'm a con law junkie, so I could do that with the U.S. Supreme Court
I know who the author was.
quite a while ago, but that's me being weird. But in a similar way, I mean, I can now do that with Colorado Supreme Court, and that really makes a substantial difference in terms of, you know, if you know that you're dealing with a particular justice, you might know that you're going to have different challenges.
I would love to do habeas corpus.
It's really complicated. I feel like I hit a wall
Yeah.
intellectually when it comes to that, which was part of the reason why they had the staff attorney specialist.
All sorts of things have the equivalent of statutes of limitations. You know, everything tolls at some point and doesn't at other points, and does and then doesn't again, and you know, turns on and off, and when it starts is not exactly clear, and when it doesn't start is not exactly clear.
What's final?
The definition of final is not consistent, primarily based on subject matter. Like when you said, I know what error is and I know what harmless means, I got to one, I don't remember now, but I got to one situation where I said, oh, I guess I don't know what error means. Because it's not the same thing here. At all.
Yeah.
And you can mess up and it's not even error.
Yeah. Well, especially with ineffective assistance.
And the
claims,
relationship
you know,
between,
it's
there's a fairly new end of 2012 Colorado Supreme Court opinion that is very useful in terms of comparing standards of review to a certain extent. It is specifically supposed to be comparing standards of review for ineffective assistance of counsel and direct appeal. But she also, Justice
The
Rice,
harmless error standard in those two contexts, or no? Okay.
they touch on that,
Okay.
What, do you know what the case name is?
it's Hagos, Hegos, and you know, people is on one side or the other. And it was Justice Rice, and it was, if you look up Strickland, which is this test for ineffective assistance, you'll get that. She did a little bit, we seem to be confused about what standards are, but quite frankly, what she had to say pretty dramatically changed a couple of other things that we thought were fairly clear. So that's the other thing, is that they change all the time, which can be a little like, no, 2 days ago.
Right. Well, it's surprising when you tend to think of laws more or less clear, more or less set, and I think that in my mind, in terms of an intellectual skill that's really lacking in the law school curriculum, typically it's sort of looking at these very ambiguous questions of, well, what law applies?
Yeah.
Even, and what does it mean for a particular standard to be met? I mean, things are pretty black and white. We're taking exams or whatever in law
Sure.
school. So, but not in this class. These guys had a very hard problem to work on, which required a lot of nuanced thinking. But I think that you're seeing how unclear the answers are.
Yeah.
And it's 2013, and there's still
Right.
questions about these things.
Oh, yes. One other thing I was going to say, has now left my brain.
Something about your writing process, because everyone who writes, most people who write seem to be like, I just write, which has never been the case for me. I have a very sort of regimented process for writing, but did you get any guidance on that, or you worked on a process that works for you, especially with deadlines?
Yes to everything you just said. Judge Russell, who has now retired from the court, he loves this stuff. He loves writing and.
He came to Judge Jones's class. He's really good about standards of review, so if you see stuff coming from like the state attorneys, the Attorney General's office, I would probably look at their cases and their standard review a lot more legitimate than the public defender's office. Yeah, I mean, it's not going to be written by him, but at least he has implemented a teaching, some materials to teach kind of how to write these standard reviews. And I tried to get it from him, but I think it's kind of proprietary.
Right.
I'll check and see
release any of it.
if what we had any of that in it. I mean, he did a great presentation for us on the writing process in general.
As part of your orientation?
Mhm.
Great. And he's going to continue to do that even
I
though
don't know.
Okay.
If
They'll
you
probably have
ever
someone do
have an
it.
opportunity to take anything, any kind of CLE training of any sort that Judge Russell does, no longer judge, I highly recommend you do it. But
Did he have a process, like a go-to process that?
part of his process is part of his teaching is explaining that you're going to need to develop your process.
Good.
And what works for some people is not going to work for other people. One piece that everyone talks about, and quite frankly, I don't know why everyone talks about it, but it's so you'll typically have 3 briefs. You'll have an opening, an answer, and a reply. There's a ton of conversation about whether you read all of this, and then you read all of this, and then you read all of this, or whether you read this issue, and this issue, and this issue, and this issue, and this. There's a lot of conversation about that. I don't particularly know why that's the focus of a lot of people.
I like to make a chart, which kind of solves the problem, right? So, read the opening brief. The issues should be clearly indicated. What are the arguments? What are the authorities? Then you read the answer brief. How does that line up? Reply brief, and that also helps you spot, are they trying to inject a new argument in the reply brief or something like that? So that, But that's interesting that, I would go crazy reading across 3 briefs. That would make me crazy.
I will do that, but I've done this first. I've gone vertically.
Yeah, right.
And then I'll check horizontally sometimes. But also, you need to think about when you're checking their research, when you're reading every case and it's not every case, but when you're reading virtually every case that the parties cite, when you're doing your own research and finding all of the cases that the parties should have cited that didn't, and when you're reading that, and when you're taking those pieces into consideration, and when you are actually writing something, and do you outline first or not, and if you do, what are you outlining, and on the basis of what are you outlining, and if you cannot comprehend what an argument is, what do you do? Is it fair to turn straight to the answer brief to try to figure out what the heck is at issue, or not? How much does the case law actually matter? That really was a little bit bizarre for me to figure out, but I've had I think 2 cases now where I've cited maybe 3 cases, and that was to basically say this is the standard of review, and yes, we can do what we just did. And that was it. One of the things that is very, very interesting, and was where I was at one point headed, is that if you take what happens is that you will find language that works really well to describe a particular idea. And so then you will use that language to describe that particular idea the next time, and then the next time. Well, at some point, the chances of your changing contexts between civil law and criminal law, between one stage of a criminal proceeding and another stage of a criminal proceeding, between all these different things, the case law is flat out wrong in in a lot of cases, because if you trace it back, you're in a totally different setting, a totally different context. So then you get into a very complicated issue, which is, yes, there is a string of precedent here about this issue and in my topic, but the fact of the matter is, it's wrong. And it's all wrong because it started out talking about cows, and now we're talking about jail clothing. And I did have something that was almost that. I mean, what do cows have to do with jail?
A standard of review that might be articulated in some kind of administrative case is going to be totally different. So that awareness of context when you do your own research is important, and also to realize that parties will cite language out of context all the time. All the time.
Most of the time.
Yeah. So you're always, again, that whole idea of, not having a crutch, not having, I like to use this language when I talk about summary judgment, go find the most recent case, even though the language is going to be the same.
Go find the most recent case. If you can find the most recent thing that your judge wrote on that, start with that, and then check what he or she cites and see if that's changed. Because also the fact of the matter is that you're writing for someone else. So, I mean, I have pushed in this a number of times. I have said, no, I'm sorry, Judge, but look, and I laid out every single case that this traced from, and he was like, oh, yeah, you're right. That's completely wrong. Okay, so now do you want me to overrule the U.S. Supreme Court or the Colorado Supreme Court first? I was like, thank you.
Not all errors are created equal, right?
Sorry. So that's it. I mean, and that changes as your amount of time clerking goes on, I think. I think everyone starts your rapport with the judge, but also I really think that every clerk starts out doing more than they have to in almost every situation.
Yeah, the learning curve is incredibly steep.
Right.
And to accept that as part of the process, that you are going to not know anything and be slow at the beginning, and to not have that imposter syndrome, where you fear, like, I shouldn't be doing this, I'm not qualified. I mean, it's really a tremendous learning experience.
And part of what's so supportive about the Court of Appeals is that you're surrounded by people who are feeling the exact same way and actually talk about it.
Yeah.
I don't know, they're feeling the same way, but I don't know if they talk about it. But that was a really big deal for me.
So this is just a little type of chart that I might use when I'm writing an opinion to set in my own mind the structure of the analysis and to look for inconsistencies or errors. I always read the lower court decisions first.
If you can find them.
Yeah. But to have a comparison across the briefs. Amicus briefs is pretty rare. That amicus briefs are going to be filed, pretty rare that they're going to be useful, but you can also include that in there as well. So it just helps you, there's a lot of information in a case, especially when you include the record, and just to get a grasp of everything that is being said and how it relates to each other, whether the story is consistent or not. Can you talk a little bit about working with the record?
Can I just ask a question? Why can't you find the district court opinion?
If they're not published, you can't really find them, can you?
It doesn't.
There's not necessarily a written opinion.
There's not necessarily a written opinion.
Okay.
And at this point, you should always be able to have, the transcript should always be on the record. I mean, in your record, but it's not always, and that's really,
so
really
be cognizant of
challenging.
there might be gaps in the record.
Yeah.
So don't assume, this issue wasn't preserved or whatever, there wasn't a hearing on this particular motion. double check that it hasn't been omitted somehow.
And also, that will matter. So, again, tying into standards of review, if there was a hearing, it's different, both for preservation issues, but also for a different piece of standards issues. And if you can't find what the judge said at the hearing that supposedly took place, then you have to figure out what you're going to do about that, because if the hearing took place and certain things were ordered on the record, but you have no record of that, you just have people referring to it.
Because a party didn't order a transcript or something? I mean, do you guys have to order your own transcript sometimes, or?
We can.
Okay.
We can also throw things out or
For
just
insufficient
rule
record.
against,
Okay.
like, you should have put this in here. You didn't. I can't prove it. I need to be able to.
Right,
Sorry.
right.
But we really, that's a pretty drastic response
Yeah.
that I don't think many judges are comfortable with.
I think if it's like a major law firm and they fail to provide a sufficient record, then
That's
they
different.
should get
Yeah.
slapped, yeah.
Yeah.
But if it's pro se, obviously, or
If it's
whatever,
pro se, and if it's, DAPD stuff, they really should do it, and for the most part, they're on top of their
Yeah.
stuff.
Yeah.
But, I can confirm, currently, I can confirm that an order was issued, but I can't necessarily find the order.
Ever? I mean, is it just a matter that, eventually you could find it, or you might?
Sure, if I
Okay.
went back, so I have a case now where the crime took place in 1988. There are 6 opinions that have been written by the Colorado Supreme Court. Why am I having this problem? By the Court of Appeals. There's 6 opinions written by us already about this case. And at a certain point, you send records back to the district court
That's the game,
because, we just moved into a brand new building and already don't have space for certain things, which is another issue. But I can't find an order that I need from 99. And if I had that order, I could be done.
Well, again, this is something law school doesn't teach you, and the basic principle, we're out of time, unfortunately, but the basic principle is be diligent, be thorough, be questioning. This is what I'm recapping what I hear you saying. Be diligent, be thorough, be questioning. That's really one of the main things, yeah.
And just know that at least in the beginning, and many other times as well, with the possible exception of the Supreme Court, but again, this isn't good practice, and they don't, shut up.
I'll come talk to your class next year about what actually goes on.
It's a mystery. I'm up there a lot more than a lot of other.
Well, it's funny,
people,
because
but-
we were there and we were back in the conference room, and Will, for whatever bizarre reason, wanted to take a picture of the robes, and he was like, "Can I take a picture of the robes?" And Justice Marquez was kind of like, "I guess. Don't put it on Facebook." But it's like, there's definitely.
Don't tell anyone.
It's weird though, because when I interned there, they said don't talk to the other interns, all the interns were together, but especially in the Denver Post building, when it wasn't as separated, it's not like people were whispering, like the clerk, when I went and talked to the clerk, Justice Rice's clerks, like, other clerks were walking by, it's not like,
Yeah.
It's different now, though.
But now
It's
they're
really
so
different.
isolated, yeah.
I don't even realize that human beings exist some days.
On the 4th floor.
No,
If you're
in my
judges.
office.
Oh.
My judge won't be there, and a couple days a week my co-clerk works from home. So I don't know that there are humans in the building. But
We were wrapping up about the idea of being questioning.
oh yes, but also you're gonna read thousands of pages of a record,
Yeah.
like thousands of pages. You don't need to do that. But until you know where the part that
Right.
you need is,
Right.
you can't. So, in addition to reading, like, I'll read on a medium complicated case, I will be reading